Now, without further ado, we now begin session 3 on maritime dispute settlement and new frontiers in judicial bodies. For session 3, His Excellency Kriangsak Kirishai-Seri, Judge of the International Tribunal for the Law to Sea, will lead the stage as the moderator. Judge Kirishai-Seri, the floor is yours.
Thank you very much. Good morning, everybody. It's very interesting to have this session on the so-called maritime dispute settlements and new frontiers in judicial bodies. The new frontiers, the panelist speakers will be talking about here will focus mainly on the 200 nautical miles, continental shelf beyond 200 nautical miles, climate change advisory opinions, and the so-called evolutive rules of interpretation of UNCLOS. We have 3 speakers and then 4 panelists. The 3 speakers will have 20 minutes to present their point of views, and then each panelist will have 50 minutes each. So we'll come to 2 hours in all. And then we have question and answer about 25 minutes or 30 minutes. It depends on the time used by the speakers here on the podium. The first speaker is Professor Alex OUDE ELFERINK. He was already introduced yesterday, so I need not introduce him again. Unless you have some kind of the lapse of memories, you can read his CV in the brochure. He will be speaking about the very interesting case that is Nicaragua against Colombia. Interesting in many ways because yesterday morning or afternoon we already heard some comments on the case. But let me put it this way. In that case, the legal team, the so-called counsel and advocates for Nicaragua were Alex himself, and then Sir Wogan Law and Alain Pele. On the Nicaragua side, led by my former colleague at the ICLS, Eduardo Valencia Ospiana, and a lady called Elizabeth Taylor. Very interesting. And Sir Michael Wood was a top lawyer for Colombia. So to make it more interesting, I'll give the floor to you to present your case, and then after that we hear the panelists. And in order to hear the other side, after all the panelists have spoken before we go to question and answer, I will give Michael Wood, my close friend and nemesis in the ILC, a chance to respond to your arguments. You have the floor. Thank you.
Okay, thank you, Judge Kirishai-Seri, for that brief introduction of the case. I think that's also helpful, and maybe at this point I should also point out, and of course, that I was counsel for Nicaragua in the case I'll be discussing, but of course the view that are expressed here, as is always the case at conference, are my own personal opinions and should not be attributed to anyone else. Could we have these slides, perhaps, or? Yes, thank you. So today I'll be addressing this question whether the continental shelf beyond 200 nautical miles of one state is limited by the 200-mile limit of another state. And the ICJ, in the case that was mentioned, provided an answer, and today I want to question this answer of the ICJ. So as already mentioned, this was a case between Nicaragua and Colombia, the question of the delimitation of the continental shelf. Beyond 200 nautical miles from the Nicaraguan coast. So it concerned the delimitation of Nicaragua's continental shelf beyond 200 nautical miles and Colombia's continental shelf within 200 nautical miles. And I included this figure just to illustrate the Nicaraguan claims. So it's the lines in bold, and as a matter of fact, they are they would give Nicaragua an extensive continental shelf beyond 200 nautical miles. But the first question, of course, would Nicaragua have an entitlement within that area beyond 200 nautical miles, that is within 200 nautical miles, in large part from the relevant coasts of Colombia. So what's also interesting about this case is the court asked, instead of having pleadings, oral proceedings on the whole case, the court asked 2 questions to the parties. And one of those is the one that's included here. That was the first question, whether under customary international law, may a state's entitlement to a continental shelf beyond 200 nautical miles extend within 200 nautical miles from the baselines of another state? And the oral pleadings focused on the 2 questions that the court asked of the parties. And there was a judgment on 13 July 2023, and the court answered the first question. That's the question you see included above on the slide in the negative, so the court indicated that there was no need to engage with the second question it had posed to the parties. So I also won't address that second question. So the court's reasoning, basically it did 2 things, I would say. It interpreted, in particular, it interpreted the UNCLOS, and in particular Articles 56 and 76, also taking into account the context, and it also looked at the establishment, and it also established the content of the customary law on the matter, because Colombia is not a party to the United Nations Convention on the Law of the Sea, so the applicable law in this case was customary law, so that raised an additional question. There have been quite some reactions to the court's finding and reasoning. There were a number of dissenting opinions, which are listed here, and they're rather critical of the approach of the court on both counts, so both of the issues I set out in the previous slide. And there's also an interesting separate opinion. There were a number of separate opinions, but I identified a separate opinion of Judge Shui here because she also made an interesting point to which I will return later. If you look at the academic debate, at least to the extent that I could identify it, it's critical of the court's approach to the determination of customary international law. But I think it's less so as regards the interpretation of Articles 56 and 76 of the UNCLOS. So in that light, I decided, I think there's also a lot to say about the way that the court identified customary international law, but I would say it's more interesting in this light to focus on the latter issue, so the way that the court dealt with the interpretation of Articles 56 and 76 of the UNCLOS. So the court started out by pointing to the integrated character of the UNCLOS, and particularly relevant in relation to Parts 5, so that's the part dealing with the exclusive economic zone, and Part 6 dealing with the continental shelf. And the court further observed that the relationship between these parts is specified in Article 56, paragraph 3. Article 56 defines the right of individual coastal states, so individual coastal states in relation to their exclusive economic zone. It does not address the relationship of the exclusive economic zone of one state with the exclusive economic zone or continental shelf of another state. And Article 56.3 indicates, and of course you can have different views on that, but it indicates, in my view, that the rights in relation to the seabed and subsoil are separate from those in relation to the water column, because Article 56, paragraph 3 specifically refers to the seabed and subsoil, and the rights in relation to the seabed and subsoil are those of the regime of the continental shelf. Also, in its reasoning, the court also quoted from the Libya-Malta case. I would say just take a moment to read through this, and maybe also good to note that I emphasized a part of the judgment, because the court said there can be a continental shelf where there is no exclusive economic zone, but there cannot be an exclusive economic zone without a corresponding continental shelf. And of course, it's not quite clear. Of course, you can read this in different ways, but I don't would say that it provides a conclusive answer that the court asked to the parties in Nicaragua, Colombia. The court also didn't provide any further explanation, but presumably reference or reliance on this paragraph from Libya Malta, the court found that it was supportive of its answer to the first question. So what else did the court say in Libya Malta? So in paragraph 34, the court also observed that where the continental margin does not extend as far as 200 miles from the shore, natural prolongation is in part defined by distance from the coast. So basically the court was only focusing on the area within 200 nautical miles from the shore of the state, so not areas that are more than 200 nautical miles from the coast of the states concerned. And that focus on areas only within 200 nautical miles is confirmed by paragraph 39 of the judgment, in my view. And you see paragraph 39 here on screen now. So I think it refers, it's also in this case, the court specifically is only referring to one coastal state and not to the relationship between the continental shelf of one coastal state and the exclusive economic zone of another coastal state. And also, if you look at the factual circumstances of Libya Malta, they are quite different from the case the court decided in Nicaragua versus Colombia. Because in Libya Malta, the coast of the parties are less than 200 nautical miles apart, as also is observed by the court itself in Libya Malta. And so in this case, the question did not turn on the question whether the continental shelf of one state beyond 200 miles could overlap with the 200 nautical mile zone continental shelf of another state, but rather on the question whether the so-called rift zone, which was the physical feature of the continental shelf in the area concerned, constituted a boundary between the entitlements of the party. And as Malta argued, or maybe it was Libya, I don't recall at the moment, whether this should also be identified as their bilateral continental shelf boundary. So the court in Libya Malta was not faced with the situation the court had to consider in question of the delimitation. So that raises the question whether, and I think also the academic literature, as far as I could establish, does not really ask this question. How relevant is it to, is Libya Malta really to the issue that was now before the court in Nicaragua versus Colombia? The court also looked at the regime governing the continental shelf beyond 200 nautical miles, and the court started out by observing that there are two bases of entitlement. And as far as I'm concerned, Article 76 does not establish a priority between these two bases of entitlement, these two bases being, of course, natural prolongation and distance from the coast. And if there is a priority, I would say natural prolongation arguably has priority over distance, because as Article 76, paragraph 1 indicates, the 200 miles apply where the outer edge of the continental margin does not extend up to that distance. And also interestingly, I won't comment further on that point, but just to note that the court subsequently does not really discuss the relationship between these two bases of entitlement, but shifts the focus to the regime for determining the outer limits of the continental shelf beyond 200 nautical miles. And one of the assumptions, I won't go over all the details, that would take too much time, but one of the assumptions of the court is that at the third United Nations Conference on the Law of the Sea that negotiated the convention, one assumption was that the continent, according to the court, that the continental shelf beyond 200 nautical miles only would extend into the area. I'm not convinced that that really was the thinking of broad margin states. I think rather broad margin states considered that their continental shelf extended throughout the natural prolongation of their land territory. And that was also recognized, of course, and that was also the basis for the claim of broad margin states at the conference. The court itself in 1969 in the North Sea continental shelf cases recognized that the basis for entitlement was natural prolongation, and this was a rule of customary law according to the court. And the court, if you look at the judgment in 1969, did not at all consider that this natural prolongation, this basis of entitlement, would be limited by a 200 nautical mile limit of other states, which at the time was really not relevant. The court also discussed the Bay of Bengal cases, and the Bay of Bengal cases are of interest because they established a boundary within 200 nautical miles of one state, but beyond 200 nautical miles of the other states. So suggesting that the continental shelf of one state within 200 nautical miles can overlap with the 200 nautical mile continental shelf of another state. The court dismissed these cases, I would say, rather easily. The court said two things. Well, the gray area is incidental result of just adjustment of a delimitation line. And so the court says it is of no assistance in answering the first question that was before the court. But I think that what's problematic here is that a gray area presupposes the existence of overlap between areas within and beyond 200 nautical miles. Otherwise, a boundary cannot be located in that area, I would say. Because how can a court or tribunal have jurisdiction to delimit an area between two states where there is only entitlement of one state? I would say that's rather problematic. And I think also if you look at the Bay of Bengal case, in particular Bangladesh, Myanmar, there was quite an extensive discussion also, or not an extensive discussion, but if you look in the judgment, there's also reference to the fact that Myanmar made the same argument as Colombia in question of the delimitation. And the tribunal in that case rejected the argument of Myanmar. So that was basically, the tribunal came up with a different answer than the court in 2023, in my view. As also witnessed by the delimitation line it drew. So briefly about the conclusions. So in my view, the arguments of the court are somewhat unpersuasive, but I assume there's good reasons for the court to take this approach and not go in any detail in its discussion. I think it also raised the interesting question whether there's a fragmentation of the jurisprudence, because in my view, it's difficult to reconcile what the ICLS and also the arbitral tribunal said in the two Bay of Bengal cases, and by the way, that in my view also applies to Somalia, the Somalia-Kenya case, which was decided by the International Court of Justice, which is also discussed in the 2023 judgment, but I decided for reasons of brevity not to go into that. Well, one question, of course, is this the final word on the matter? Well, as far as the ICJ is concerned, in any case, likely to be yes. I'm not sure whether that also would be the case for the ICLS or for arbitral tribunals. But of course, that also depends on how they look at this issue now that they also have this decision by the International Court of Justice. So it's, of course, too early to say anything about this. Maybe also, as a final point, also interesting to ask the question, why did the court take this rather unusual approach of not allowing the parties to fully plead their case, but only have them answer to specific questions during the oral proceedings? And as far as I know, this was a first, but maybe there's people in the audience who could correct me, but I think this is one of the first cases, or the first case where the court took this approach. And there's an interesting indication in both the dissenting opinion of Judge Tomka and also the separate opinion of Judge Shui. And they both seem to suggest that the court had difficulty in coming to grips with the, let's say, scientific or technical questions that were before it. And basically that's explained by the fact that that the parties had very different views on the geomorphology of the area concerned, and also their scientific and technical experts. But that raises, of course, the question, if this is the real reason for the court taking the approach it did, is that the proper way of handling these issues? I have the impression, if I read, for instance, what at least some of the judges said in the Maldives-Myanmar case, that they, or the Maldives-Mauritius case, my apologies, that they hold a different view and that they might have approached this situation differently. But of course, We don't know. That's a speculation. But I think it's still interesting to maybe also in this respect consider whether, if you look at how the ICLS has approached different cases, how it would have dealt with this case, would it have been before the ICLS and arbitral tribunal. So that concludes my presentation. Thank you for your attention. I'm looking forward, of course, to the discussion.
Thank you very much.